Hello everyone. In the last presentation, the important aspects of the freedom of speech and expression guaranteed under Article 19(1)(a) have been explained. The various heads under which the legislature can impose reasonable restrictions on this right will be dealt with in this presentation. Clauses 2 to 6 of Article 19 empower the state to make laws imposing reasonable restrictions on the freedoms guaranteed under Article 19(1) in the interest of the general public, security of the state, public order, decency or morality, and for such other reasons set out in those clauses. Article 19 is so structured that each freedom guaranteed in Article 19(1)(a) to (g) is subject to different set of restrictions in clauses 2 to 6 of Article 19. Interchanging these restrictions for regulation of the freedoms is not permissible. This means that the right to freedom guaranteed by Article 19(1)(a) can only be restricted on the grounds mentioned in Article 19(2) and no further. In order to be constitutionally valid, two conditions have to be satisfied by a law restricting the exercise of any of the 6 freedoms guaranteed by Clause 1 of Article 19. The restriction should be for the specific purpose mentioned in the clause providing for imposing restriction on that particular right, and the restriction has to be a reasonable restriction. Whether a restriction imposed by a law made by the legislature is reasonable or not is subject to judicial review, that is, the supervision of courts. The expression reasonable restrictions is not defined in the Constitution. The test of reasonableness has to be applied to each individual statute challenged, and no abstract standard of reasonableness can be laid down as applicable to all cases. In Chintaman Rao versus State of Madhya Pradesh, the Supreme Court observed that the nature of the right that is being restricted under the law in question, the purpose for which the restrictions are imposed, the extent and urgency of the evil sought to be remedied, the disproportion of the imposition, the prevailing conditions at the time, and the duration of the restrictions are some of the factors that have to be taken into consideration by the court while deciding the reasonableness or otherwise of the restrictions. The standard varies with time, space, and condition and from case to case. The Supreme Court affirmed some principles for ascertaining the reasonableness of restrictions on the exercise of the rights guaranteed under Article 19. As these restrictions are limitations imposed upon a person in the enjoyment of his right, it should not be arbitrary or excessive in nature and has to strike a proper balance between the freedoms guaranteed under Article 19(1) and the social control permitted under clauses 2 to 6 of Article 19. In determining the reasonableness of a statute, both the nature of the restriction imposed and the procedure prescribed by the statute for enforcing the restriction on the individual freedom have to be taken into account. So, the principles of natural justice are an element in considering the reasonableness of a restriction imposed under Article 19. Discretion vested in an administrative authority is also a relevant factor, and if it is properly controlled and safeguarded, it is reasonable. Reasonableness of a restriction has to be determined from the perspective of the interest of the general public and not from the point of view of the persons upon whom the restrictions are imposed or upon abstract considerations. The court has to ascertain the reasonableness of the restriction and not of the law which permits the restriction. A law may be reasonable, but the restriction imposed by it on the exercise of freedom may not be reasonable. The word restriction also includes cases of prohibition, and a law depriving a person of his fundamental right under certain circumstances may amount to reasonable restriction only. The Constitution framers deliberately avoided the use of the expression due process and used a more definite word reasonable. The test of reasonableness of restriction has to be considered in each case in the light of the nature of the right infringed, the purpose of the restriction, the extent and the nature of the mischief required to be suppressed, and the prevailing social and other conditions. A restriction imposed can be considered reasonable if it is intended to carry out the directive principles of the state policy. A tax is not a restriction on any of the freedoms guaranteed under Article 19, and just because a tax imposed is excessive, it cannot be a ground for challenging it as a restriction on one of the freedoms in Article 19(1). The court has, however, asked for precaution in imposing taxes in respect of freedom of speech and expression under Article 19(1)(a). In Modern Dental College and Research Center versus State of Madhya Pradesh, the Supreme Court evolved the test of proportionality to adjudicate on reasonableness of restrictions. The Supreme Court held that the limitation of constitutional right will be permissible if it is designated for a proper purpose. The measures undertaken to give effect to such limitation are rationally connected to the fulfillment of that purpose. The measures undertaken are necessary, and there are no alternative measures that may similarly achieve that same purpose with a lesser degree of limitation, and there has to be a proper balance between the importance of achieving the purpose and the social importance of preventing the limitation on the constitutional right. Under Article 19, when the invasion of a right is proved ex facie, the state has to prove that its case comes under clauses 2 to 6 of Article 19. The burden of proving to the satisfaction of the court that the restriction is reasonable is on the state, and it is not for the petitioner to prove that the restriction was not reasonable. The harsher the restriction, the heavier is the burden to prove that the restriction is reasonable. Now coming to Article 19(1)(a), the freedom of speech and expression and liberty of press guaranteed under Article 19(1)(a are not absolute, and Clause 2 of Article 19 specifies the limits up to which this freedom may be restricted. The legislature can impose reasonable restrictions on this right under the following heads: security of state, friendly relations with foreign states, public order, decency and morality, contempt of court, defamation, incitement to an offence, and sovereignty and integrity of India. Reasonable restrictions under the above heads can be imposed only by a duly enacted law and not by an executive action. Coming to the first ground under Clause 2 of Article 19, reasonable restrictions on the freedom of speech and expression can be imposed in the interest of the security of the state. The security of the state may be endangered by crimes of violence intended to overthrow the government, waging of war and rebellion against the government, external aggression or war, etc. All utterances intended or calculated to have the above effect may be controlled in the interest of the security of the state. Serious and aggravated forms of public disorder fall within the expression security of the state, but every public disorder cannot be regarded as threatening the security of the state. The expression does not refer to ordinary breaches of public order, which do not involve any danger to the state itself. After the Constitution First Amendment Act 1951, public order also has been added as a ground for restrictive laws. The next ground, that is friendly relations with foreign states, was added by the Constitution First Amendment Act 1951. The state can impose reasonable restrictions on the freedom of speech in the interest of friendly relations with foreign states. The justification for this restriction is that uncontrolled hateful propaganda against a friendly foreign country may endanger the maintenance of good relations between India and that country, and hence has to be checked. A law which makes it an offence to publish any libel likely to degrade or expose to hatred or contempt any foreign prince, ambassador or other foreign dignitaries will fall within this expression and will be held valid provided the restrictions are not unreasonable. The preservation of public order is one of the grounds for imposing restrictions on the freedom of speech and expression. This ground was also added by the Constitution First Amendment Act 1951. The expression public order is identical with public peace, safety, and tranquility. It denotes absence of disorder involving breaches of local significance in contradistinction to national upheaval such as revolution, civil conflict, or war affecting the security of the state. Clause 2 has used the words in the interest of public order and not for maintenance of public order. A law may not have been intended to directly maintain the public order, and yet it may have been enacted in the interest of public order if the law assists in maintenance of public order. Thus, a law punishing utterances made with deliberate intention to hurt the religious feelings of any class of persons is valid, since such speech or writing has the tendency to create public disorder, even if in some cases those activities may not actually lead to a breach of peace. But there has to be reasonable and proper relationship between the restriction and the achievement of public order. If the restriction has no proximate relationship to the achievement of public order, it cannot be said to be a reasonable restriction within the meaning of Clause 2 of Article 19. Section 144 CRPC dealing with issuing prohibiting orders by a magistrate to maintain public order. Section 124A IPC punishing sedition. Section 505 IPC punishing issuing of statements tending to cause public mischief, and Section 123(3)A of the Representation of Peoples Act, which defines corrupt practice in elections, have been recognized as reasonable restrictions on the freedom of speech and expression in the interest of public order. Decency or morality is another ground on which the freedom of speech and expression may be reasonably curtailed. Decency connotes lack of obscenity. The right to freedom of speech and expression cannot be permitted to ruin and corrupt the community, and therefore writings or other objects, if obscene, may be suppressed and punished because such action would promote public decency and morality. Sections 292 to 296 of the Indian Penal Code, that is sections 292 to 294 of Bharatiya Nyaya Sanhita 2024, prohibit the sale, distribution or exhibition of obscene matter, or the doing of obscene acts, or singing obscene songs, or uttering obscene words in the public places. The Penal Code does not lay down the test to determine obscenity. In Ranjit D. Udeshi versus State of Maharashtra, the Supreme Court for the first time was called upon to lay down the test to determine obscenity. The facts were that the appellant, a Bombay bookseller, was prosecuted under Section 292 IPC for selling and for keeping for sale the well-known book Lady Chatterley's Lover, written by D.H. Lawrence. The magistrate held that the book was obscene and sentenced the appellant. The matter was taken before the Supreme Court. The main question before the court was, when can an object be said to be obscene? In spite of the protest of the counsel of the appellant that the test was outmoded and needed modification, the court agreed with the Hicklin test, according to which a matter charged is obscene if it has the tendency to deprave and corrupt those whose minds are open to such immoral influences and into whose hands a publication of this sort may fall. But exception could only be made if some important social purpose was served by the obscene object. Applying the above principles, the court held the novel in question as obscene. But in Avik Sarkar versus State of West Bengal, the Supreme Court held the Hicklin test not correct and applied community standard test to determine obscenity, according to which an object is said to be obscene only if it is suggestive of depraved mind and designed to excite sexual passion in persons who are likely to see it. Only those sex-related material which have a tendency of exciting lustful thoughts can be held to be obscene, but the obscenity has to be judged from the point of view of an average person. However, books, pamphlets, writings, or paintings used for bona fide religious purposes or paintings in any temple are exceptions to Section 292 Indian Penal Code. The next ground on which the freedom of speech and expression can be curtailed is contempt of court. The constitutional right to freedom of speech would not prevent the courts to punish as contempt of themselves spoken or printed words calculated to have that effect. The expression contempt of court is now defined by Section 2 of the Contempt of Courts Act 1971. Contempt of court can be civil contempt or criminal contempt. Civil contempt means willful disobedience of any judgment, decree, order, direction, writ or other process of a court or willful breach of undertaking given to the court. Criminal contempt means the publication by words spoken or written or by signs or visible representations or otherwise of any matter or the doing of any act whatsoever which scandalizes or lowers the authority of any court or prejudices or interferes with the due course of any judicial proceedings or interferes or obstructs the administration of justice in any other manner. Judges have no general immunity from criticism of their judicial conduct, provided that it is made in good faith and does not impute any private motive to those taking part in the administration of justice. It must be genuine criticism and not malicious or an attempt to impair the administration of justice. Articles 129 and 215 of the Constitution empower the Supreme Court and the High Courts respectively to punish people for their respective contempt. The Contempt of Courts Act 1971 defines the power of the High Court to punish for contempt of its subordinate courts. While the right to expression of free opinions is essential to a free society, the constitutional law itself imposes restrictions in relation to contempt of court, and therefore it cannot be said that the right abolishes the law of contempt or that attack on judges and courts will be condoned. Power to punish for contempt of court under Articles 129 and 215 is not subject to Article 19(1)(a). In Narmada Bachao Andolan versus Union of India, entertaining a petition against the remarks of leaders of the Narmada Bachao Andolan, the Supreme Court noted that the freedom of speech and expression does not include the freedom to distort orders of the court and present incomplete and one-sided picture deliberately, which has the tendency to scandalize the court. After expressing its anguish on these remarks, the court dropped the proceedings. The next ground is defamation. Defamatory matter is matter which exposes a person about whom it is published to hatred, ridicule, or contempt. Defamation may be in the form of libel or slander. If the defamatory matter is in writing, printing, or other permanent medium, it is libel. If it is in spoken words or actions, it is a slander. Right to free speech does not entitle one to violate the rights of others, and right to reputation is one such right. Incitement to commit an offence is also a new ground added in 1951. Obviously, the freedom of speech cannot confer a license to incite people to commit offences. In State of Bihar versus Shailabala Devi, the Supreme Court held that incitement to murder or to commit other violent crimes would generally endanger the security of the state, and a restriction against such incitement would be a valid law under Clause 2 of Article 19. Reasonable restriction can also be imposed on the freedom of speech and expression if it is to uphold the integrity and sovereignty of India. This ground has been added by the Constitution's 16th Amendment Act 1963. This amendment is made to guard the freedom of speech and expression from being used to attack the territorial integrity and sovereignty of the Union. Thus, the Parliament is empowered under this clause to restrict the right of free speech if it breaches secession or separation of any part of India from the Union. The restriction here is with respect to territorial integrity of India and not on the preservation of the territorial integrity of the constituent states, because the Constitution itself under Article 3 contemplates changes of the territorial limits of the constituent states. Sedition is not mentioned as one of the grounds on which restrictions on the freedom of speech and expression may be imposed. In India, Section 124A of the Indian Penal Code defines the offence of sedition. Though the language adopted is that of English law, it has been interpreted widely by the courts in India. Under these decisions, criticism of the government could amount to sedition only if the words excited or attempted to excite hatred, enmity, dislike, contempt, or ill will towards the government, though there was no incitement to violence or disorder. The constitutionality of Section 124A Indian Penal Code in relation to freedom of speech was questioned in Kedarnath Singh versus State of Bihar. The Supreme Court held that the section is not ultravirus the Constitution. The gist of criminality in an offence of sedition, as defined in Section 124A IPC, is that the words written or spoken should have a tendency or intention of creating public disorder or disturbance of law and order. In Vinod Dua versus Union of India, the accused journalist was alleged to have uploaded video on social media by making false allegations for which he was prosecuted for offences punishable under sections 124A and 505(1)(b) of Indian Penal Code. As the statements were neither made with an intent to incite people nor showed tendency to create disorder or disturbance of public peace by resort to violence, the accused was held to be within permissible limits, and therefore prosecution was held to be unjust and violative of rights guaranteed under Article 19(1)(a) of the Constitution, and the FIR for the aforesaid offences was liable to be quashed. When the constitutional validity of Section 124A IPC was challenged in S. Bombatkere versus Union of India, it was stated on behalf of the Government of India that it has decided to re-examine and reconsider the provision of Section 124A IPC before the competent forum. The Supreme Court held that till the re-examination of the provision is complete, it will be appropriate not to continue the usage of the above provision of law by the government. This, in brief, is about the grounds on which reasonable restrictions can be imposed under Article 19(2) on the right to free speech guaranteed under Article 19(1)(a) of our Constitution. Thank you.